We're connecting, one moment. Okay, we are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. We're here on a single justice matter, cases number 21J195 and two additional cases. I wanted to thank everyone for their participation in this case. I wanted to thank the three petitioners for a well-presented petition, and I wanted to thank the department for its response, which we received yesterday. I do have a couple of questions, but I thought first, particularly in light of the department's response and its recognition of a need to have a remand and the changed circumstances regarding placement, that I should give the petitioners and the department each an opportunity to make any additional comments which you may wish to make. And we can, having a conversation on Zoom is difficult. This isn't necessarily quite at the same level of formality as an oral argument before a panel. And so I'll guess we'll do mother, father, child, and then department. But I'm also open to having more of a round robin discussion if it turns out we need that. Maybe we won't. But Attorney Hoffman.
Thank you very much, Your Honor. Good morning. So I represent the mother, Haley Carson, one of the petitioners. I had an opportunity to speak with her yesterday evening after receiving DCF's response, conceding and agreeing to a remand. And I will actually maybe ask you, Your Honor, for a little bit of response for my own edification. I did not have a realistic expectation of anything more than a remand. And so for that reason, based on that understanding of my own, my client is happy to accept DCF's request that the case be remanded for a new hearing. The only way I would disagree and ask for anything more is if there were a possibility that this court could order custody in the way my client would like. So you're shaking your head no, so I'm assuming
I think you read the tea leaves correctly, counsel.
Okay. All right.
I concur with the department's position that a remand is required because of the procedural context of the case. And my questions have to do with what that remand order should look like.
Okay.
Obviously, the existing order needs to be vacated, but that leaves a vacuum.
Right.
And so I would, and I should have said this at the outset, and thank you for your diplomatic prodding. But I do want everybody, different people may have different views of this, but this is not a fact-finding court. The error that the three petitioners have alleged is an error of process. The appropriate fact-finding cannot be made until that process is completed. So I think we've all ended up on the same page in that score. But the question becomes then whether there should be anything else in the order, how we handle the time period in the interim, how soon you think you're going to get a 72-hour hearing. And while this may be falling off a bicycle for those of you who appear in juvenile court regularly, it is not as common here, although I am learning in my month of single justice quite how many walled type petitions we're seeing.
Right.
So I take it from your clients. Does your client have the other thing that was represented to us is that custody was being returned to placement was being made with the grandparents.
Right.
And do you have a response to that representation?
I do, Your Honor. And number one, I appreciate the department letting me know. Number two, I appreciate the fact that the department did place the child with the grandparents. That's, I don't think it's a controversial statement to say that is the answer in a lot of these cases, that it lessens the impact of removal to be able to be with a familiar face, particularly grandparents. That said, Your Honor, that is irrelevant to the custody issue at the 72-hour hearing. In other words, the parents and child should still be able to go forward and seek a return of custody to themselves or any other custodial arrangement, and then have as a knowing in the back of their mind that if they are unsuccessful, that at the very least the children will be placed by DCF with the grandparents. There is a significant legal distinction between DCF custody and placement on one hand and custody orders on the other. So my client, singular, would still exercise her right to the 72-hour hearing. Well, let me say this, Your Honor, I'm not trial counsel, so I'm going to leave that to my client and her trial counsel. She may decide based on that it makes sense. I really don't know. I'm going to let trial counsel handle that part of it. But at this point, based on my client's directions to me as recently as last night, she is interested in exercising her right to the new 72-hour hearing. The other thing I'll just mention, in other counsel on this call is probably much better versed than I am. As a practical matter, my understanding is, and I don't practice in Berkshire Juvenile Court, but my understanding is there's not many judges out there. I think there's only 2 judges. And so I think one of the questions, you didn't say this specifically, but I'm again reading into the tea leaves here, as to whether it should be not just remanded, but remanded with instructions to or away from a particular judge. I'm not asking for any specific relief in that regard.
Oh, no, I wouldn't
judge.
assign it to a judge, but if any of you have observations on what the anticipated timeline might be or what the anticipated timeline should be, a well-informed order from this court is, I assume, what you want, and it's one reason why I went forward with the hearing today, even in view of the department's.
Yeah, I can share one, fourth-hand hearsay tidbit, Your Honor, which is my client's trial counsel told me that she had already heard from the court about scheduling a hearing. She didn't say what date they were looking at, but apparently the court is on this and is processing it already.
Okay. Thank you.
Thank you, Your Honor.
Attorney Toby?
Yes, Judge, thank you. Representing the father, Carl T. I would echo pretty much everything that Attorney Hoffman has said. And while I do appreciate the department's placement with grandparents, I also echo the fact that that's not relevant. It's the parents' right to have a hearing as to the custody of their children. So anything to, my client, I spoke with trial counsel, but not with my client. I didn't receive the department's response until this morning, so I didn't have an opportunity. But my trial attorney, Attorney Brewer, did speak with my client, and he was fine with the remand. Of course, as if I were practicing as a trial attorney, the least that I would want would be a return of custody with conditions. Assuming the case would stay open, returning custody to the 2 parents with conditions. Obviously, your court, Your Honor, cannot make that order specifically, but that's what my client would be asking for ultimately. Obviously for a hearing, but that's what we would hope to lead to resolving at this point, Judge.
All right. Attorney Levin?
Yeah, thank you, Your Honor. I have very little to add to my colleagues. I would just note, and there's nothing that any of us can do about it at this point, but there's, I think, several issues as a result of this remand that will remain unresolved, that were briefed. We may be back here for those, but I know that, in light of this arrangement, this agreement for the remand, we're not going to be able to address those today. So I think the best we can do is to have an order for a TCH to be scheduled at the court's earliest convenience. I practice a little bit out of Berkshire Juvenile Court. I know that they're scheduling them pretty quickly. I can't really say anything beyond that. But I do agree with and echo the comments of my brothers with regards to the importance of all of our clients having the opportunity to seek custody for themselves, and then at their leisure be able to place with the grandparent.
Okay.
Judge, if I may add one more thing, I'm sorry, that I don't know if your order could reflect the issue that came up in this case, which often seems to be swept under the rug, that is the preliminary hearing. It seems to be this ephemeral thing that that nobody really understands. It's not really a hearing. And I think that's really the crux of this case, is that trial attorneys need to be more aware of what takes place at that hearing. It's in the statute. It's a step that is required to be taken in order to get to a 72-hour hearing. And I think many times it's what is said at that hearing is very revealing and can often derail a case or resolve a case. So to the extent that Your Honor could make a comment in your order about the importance of preliminary hearings and considering whatever evidence or information is conveyed at that time, my client would appreciate that.
Who will be speaking for the department?
I will, Your Honor.
Have you any further response or any comments you wish to make regarding the positions of the petitioners?
Your Honor, I would reiterate what the department wrote in its response, that we think that the best course of action at this time is to remand the case back for a 72-hour hearing. And I think it would be desirable that the hearing occurs as early as possible. That is all at this time.
Okay. And the child is being transferred to the grandparents today.
That's correct, Your Honor.
And I don't hear any expression of concern about arrangements for visitation. I reread Walt this morning to make sure that I understood what the scope of my authority was and what my obligations are. I take it from this discussion that it appears that the parties are working together, and you'll be able to address those issues. If I'm wrong about that, speak up. But I also just had a question about this case. And have I pronounced your name correctly, Attorney Jespersi?
Yes, Your Honor.
Okay, thank you. What is a spin-off report?
Well, I am not certain about that, Your Honor, but I think it was referring to the conversation that the judge had with the social worker.
Well, the social worker says that she got a spin-off report from a response worker, and so I was wondering if is that oral? Is it written? Has it been provided to the parties?
Not that I am aware of, Your Honor. It has not reflected on the record, and it is not clear whether it's a written report or an oral report, but my understanding was that it was conveyed to the judge.
I understand. I think the parties are saying that they're entitled to have it conveyed to them. And to the extent that there is a problem in the case that requires a new 72-hour hearing, I just want to make sure that the appropriate due process protections are in place so that we don't come back. So if there is a written report, it seems to me, as with all other departmental reports, it would need to be provided to counsel for the mother, father, and child. Is there any problem with that?
Your Honor, I don't have any problem with that. At that trial, at a 72-hour hearing, the parties would have the opportunity, and that is the point of this, for them to have the opportunity to raise all of these issues.
That's right, but it can't wait until the 72-hour hearing. The point of the petitions and of cases like adoption of Luke is that the parties have to be on notice sufficiently in advance that they can subpoena witnesses if they so choose. They may not choose to do so, but if they so choose, that's the bottom line of our hearsay cases. So what I'm looking for is a commitment that the department will get the information to the parties in whatever form it has it. If it's an oral report, you'll convey the information. If it's a written report, you'll convey the written report.
And that is correct, Your Honor.
Okay. If I were to issue an order vacating the order on the 72-hour hearing and remanding for a new a new 72-hour hearing, but staying, I think I have to do something along the lines of either staying, and I haven't decided which, but I'm looking for all of your input, either staying the effect of vacating the order for 14 days in order to permit the new 72-hour hearing to take place. Or I can do what the judge did in Walt, which is order certain conditions, i.e. placement with the grandparents, etc. Do any of you have views on that? Is it realistic to think we'll have a new 72-hour hearing within 14 days? I can't, if I vacate the order, I've disrupted the placement decision, right? So we have to come up with something to bridge.
No, Your Honor, DCF has custody from the preliminary hearing.
Okay,
So they would, so my reading of it would be, we would
Okay.
just go back in time to the day before the 72-hour hearing, which is DCF has custody. They've made a placement decision, and then the 72
right.
would be scheduled by the court. Can I ask, Your Honor, you're referencing 14 days. Is that, I'm not familiar. Is there a limit to how long is that the window of time in which the juvenile court would have to schedule? What's the 14 hours or 14 days reference to?
I was suggesting 14 days because I
Okay.
assume you don't
Okay.
want this to drag on. It could be 30, but given what you're saying to me, I don't have to set a time limit if you think that vacating the 72-hour notice is not going to disturb the custody. If you're all in agreement on that, then that worry evaporates somewhat. And if you're confident that you're going to get a timely hearing, then I don't have to set a time limit.
Right.
But I'm
I don't know
asking-
about the timely hearing. I can't speak for the juvenile court, but like Attorney Levin said, his experience is that they're on them.
Correct.
And like I said, my client's trial counsel did mention that she had already heard from the court about scheduling. That doesn't mean that it's going to be scheduled soon, but she's at least heard from the court about it.
Well, thank you for your input. This has been very helpful. I hadn't thought, I had thought the default from vacating a 72-hour might be to 0, but you're saying that the default is to the 24 hours. So from the
That's my reading of it.
emergency.
That's my reading.
Okay, then that solves that problem. That's frankly the major reason why I wanted to make sure to hear from everybody today, was to ensure that the order that we issued was appropriate. Okay, well, based on the department's representation that it will get the information regarding the spinoff report to council in whatever form it may exist, and your positions today, I think I know what I need to know in order to issue an order. Is there anything else anyone would like to say?
No, Your
Okay,
Honor. Thank you.
all right. Well, thank you all very much. Much appreciated. Take care.
Thank you very much.
Thank you.
Okay, bye-bye.